What can a presidential executive order accomplish? On September 22, 1862, President Abraham Lincoln announced his now immortal Emancipation Proclamation. I quote, that on the first day of January 1863, all persons held as slaves within any state or designated part of a state, the people whereof shall then be in a rebellion against the United States, shall then, thenceforward, and forever be free. Lincoln's executive order was crafted as a legal document, but it also contained strong political undertones. An executive order is a presidential statement directing how administration officials and agencies are to effectuate an enacted federal law or constitutional directive. Executive orders do not empower by themselves the president to impede or subsume Congress's or the judiciary's constitutional role. The framers' focus, with James Madison in the lead role, creation of a Republican small r government by way of a written document centered on the people of the nation collectively, as declared in the preamble's introductory words, "We the people of the United States." From our school civics lessons, we recall that a three-branch federal structure was agreed to in Philadelphia with a design to protectively shield against the emergence of a monarch or a tyrant. I'm quoting, "Power should be a check to power. Constant experience shows us that every man lavished with power is apt to abuse it." Madison fully embraced this political axiom articulated by French philosopher Montesquieu. The Madisonian-influenced constitutional plan provided for Article 1, the legislative branch. Among numerous assigned functions, it would write all necessary and proper legislation. Article 2, the executive branch. A single president is to execute the laws. Article 3, the judiciary. The judicial branch was vested with powers to settle disputes among people of different states and to guarantee to every defendant a right to a jury trial. The Constitution signed 238 years ago included the following provision. Article 6, paragraph 2. Again, I'm quoting. "The Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made, or which shall be made under the authority of the United States, shall be the supreme law of the land." Under Article 1, Congress has been authorized to create statutory independent agencies to supervise a subject area too complex and dynamic to be regulated by passage of a single unruly statute. Historically, independent federal agencies such as the National Labor Relations Board, the Federal Communications Commission, the Federal Reserve Board, the Social Security Administration, and the Federal Elections Commission, to name but a few, are not subject to direct control by the president or the executive branch under congressional enabling legislation. Over the past few years, litigation has been initiated grounded in theories of constitutional separation of powers to challenge the way in which independent agencies are managed operationally and to determine which branch of government is properly granted that function. Congress claims it is the rightful branch by virtue of Article 1, Section 8, where it is vested with authority, and I quote, to make all laws which are necessary and proper for carrying into execution the foregoing delineated powers. The executive claims it is the rightful branch for such authority under Article 2, Section 1, which asserts such power, and I'm quoting, shall be vested in a President of the United States of America. The framers of the Constitution were clear about one thing in their discussions about who would not be installed to lead the federal government: a monarch or a tyrant, either by express designation in the document or by architectural defect in the framework that may allow any president to accumulate additional power in a bold maneuver or in a cloaked, secretive fashion during a term in office. Legal constitutional scholars have pondered the consequential reach of the Article 2 vesting clause and the take care clause stacked together, as those grants in the executive branch appear to push hard against the Article 1 grant to Congress to write all necessary and proper legislation. Undoubtedly, most of you have heard of a Supreme Court opinion from last summer captioned Trump versus the United States. The first obvious consequence of that decision is that a former president, quoting again, is absolutely immune from criminal prosecution for conduct that falls within his official duties. The 6-3 decision by the justices on the court also yielded a more nuanced, but arguably even more consequential result: the determination that the executive office is vested with expanded and exclusive presidential powers. This part of the holding in the Trump case was unexpected and surprising to regular followers of the Supreme Court. The resonance of this aspect of the Trump case, the creation of an executive branch sword awarded to the president, has created a basic reordering principle in constitutional law. The Supreme Court's expansive holding on the scope and range of exclusive presidential powers under Article 2 is now percolating in the litigation area. Numerous independent agencies are testing whether their congressionally defined mission and operational mechanics will survive an attempt at executive branch takeover. It is appropriate here to address a fundamental principle of law, the century-old concept of stare decisis, and how it plays out in all courts, federal and state. Stare decisis is the established rule of law to abide by prior legal precedents determined by courts over the decades and centuries. The Supreme Court has written that stare decisis, quoting, contributes to the integrity of our constitutional system of government by ensuring that legal decisions are founded in law rather than the proclivities of individuals. On August 26, 2025, President Trump declared during a televised cabinet meeting that, and again I quote, "I have the right to do anything I want. I am the president." His claim is being tested in many cases now winding through the federal court system. Numerous of them are expected to reach the Supreme Court. The real consequences of the Trump case decision are revealed by the firing of NLRB, National Labor Relations Board member Gwen Wilcox, on January 28, 2005, by email sent at the president's direction. Ms. Wilcox received the following message, and I quote, "Article 2 of the U.S. Constitution vests the entire executive power in a single president, who alone is accountable to the people." Continuing, "The aims and purposes of the administration with respect to the work on the board can be carried out most effectively with personnel of my own choosing. To that end, effective as of this date, Gwen A. Wilcox and Jennifer Abruzzo, who was general counsel for the NLRB, are hereby removed from the office of members of the National Labor Relations Board." Background information pertinent to the firings are as follows. The National Labor Relations Board was created by Congress as a multi-member federal independent agency. Contrary to that statute, Board member Wilcox was fired without stated cause. The issue in her case involves analysis of a 1935 Supreme Court case, Humphreys Executor versus United States, where the Supreme Court held that, and I'm quoting, "experts in independent agencies created by Congress and appointed by statute for a term of years are protected from the unilateral decision of the president to act at will." The court in Humphreys' Executor case unanimously ruled 9-0 that the president did not have the legal authority to fire a commissioner of the Federal Trade Commission without cause. Gwen Wilcox has a lawsuit pending against President Trump before the Supreme Court for her unlawful termination as a member of the Labor Relations Board. At the federal district trial level, and relying on the Humphrey case precedent, the presiding judge ruled that Ms. Wilcox's dismissal by the president was unlawful and that she would remain a member of the board until the expiration of her designated term. The Supreme Court subsequently blocked that reinstatement order by issuing a superseding order on its quote-unquote emergency docket. Presently, Ms. Wilcox may no longer participate in NLRB matters under consideration, with only 2 remaining members on that board, insufficient legally to constitute a quorum to conduct business matters on its agenda. The board is unable to operate. The NLRB has been put in mothballs for the time being by presidential action. The Supreme Court has put other cases on its scheduled docket, added since January 20, 2025, following its decision in Trump versus United States. They include birthright citizenship as defined by the 14th Amendment, Section 1. Roving immigration patrols involving ICE under the direction of a presidential executive order. The application of the Alien Enemy Act of 1798 in federalizing National Guard troops to patrol areas designated by the President. Dismantling the Department of Education by executive order. The general use of tariffs based upon a declared state of emergency issued by the President under the International Emergency Economic Powers Act of 1977. Executive branch impoundment of congressionally authorized funding for purposes approved by the House and Senate. We should expect the Supreme Court to give clear, written legal analysis supported by solid case law authority in its resolution of these issues. Will it? Will the court invoke the historical legal principle of stare decisis in reaching its decisions? Public confidence in the Supreme Court is enhanced when it employs rational, authoritative, and credible explanations to support its determination of issues. On the other hand, the court subjects itself to scholarly and public criticism when it consciously ignores stare decisis and directly overrules prior case law precedent, especially when that overruled case has been accepted and relied upon as applicable law for decades. The continuing successful progress of American constitutional democracy is in the hands of the Supreme Court.